Brought to you by Nova Shuddh Ghee.
जब जब खाए दिल खुश हो जाए सदियों का
नोवा शुद्ध देसी घी सपना स्वस्थ भारत का।
I love ghee.
When you were a judge, you gave, for example, a former colleague of mine, Arnab Goswami, you were heading a vacation bench at the time. You speedily granted him bail, rightly so, we believe, because the manner in which he had been confined, I believe, was he had been wrongfully confined, and therefore you gave him bail speedily. Then you have a Siddiq Kapan, another journalist, lesser known, spends more than 2 years in jail and is not granted bail. And I can give you a number of cases where individuals who perhaps do not have the same access or are not VVIPs do not get bail instantly. Article 21, which guarantees the right to protection of life and liberty of all persons, and Article 32, which allows citizens to approach the court if their fundamental rights are being violated. The question then arises, this is there in the letter of the Constitution, but is the spirit being embraced? Because I specifically refer to laws that have been brought in by government, by Parliament, UAPA, PMLA, that make it very, very difficult for a citizen to be able to enforce his rights enshrined under Article 21 of the Constitution, right to life and liberty. The very nature of the law means that most courts deny bail at the very first instance, and you spend years in jail if you're arrested under UAPA or PMLA. So the difference between the letter of the law and the spirit of it, and therefore the heart and soul of the Constitution, is somewhere being eroded.
You know, one of the fundamental aspects of our law has been the presumption of innocence. That unless a person is proven to be guilty, that person is presumed to be innocent, which means, as Justice Krishna has said, bail must be the rule, jail must be the exception. Now, our laws, including, some of the recent laws, have imposed very stringent, requirements before bail can be granted. What can the judges do in a situation like that? The task of a judge is not an easy task. But one thing which judges can do, and which the Supreme Court has done, it began with a judgment by Justice Suryakant a year or 2 years ago, which is really a very significant judgment, is this: that if the trial is unlikely to conclude at a reasonably foreseeable future, then the right to a fair trial, which means an expeditious trial, cannot be denied. In other words, if the trial is not going to conclude earlier, then irrespective of the stringent requirements of that particular law, bail must be granted to that individual. Suppose there are 100 witnesses which are cited by an investigative agency. Now, those 100 witnesses are not going to be examined until, say, 5 years or 6 years or 7 years end. What if that person is eventually acquitted? That means that person would have spent 5 years in jail, though that person was eventually held to be innocent. So one way of enforcing the right to life under Article 21, which you have rightly highlighted, is to ensure that this is borne in mind by the courts. Namely,
go ahead.
Namely, that unless the investigative agency can be put to a temporal limit, that you're going to conclude the trial within, say, a year, or you're going to conclude the trial within a foreseeable period, bail should be granted.
I don't know whether you know where I'm taking you to, but one of the contentious issues, based on exactly what you said just now, is the Umar Khalid case, which has attracted so much of media attention. He spent 5 years in jail. He and other activists arrested under UAPA for their alleged role in a conspiracy of the Delhi riots of 2020. Trial hasn't begun. The court says there are hundreds of witnesses who still have to be produced before the court. His continuing incarceration, isn't it against the spirit of Article 21?
Rajdeep, I've made my point clear on the issue of principle.
Yes.
And I believe that the principle which I have spoken about now as a citizen, not as a judge, must be applied across the board. On this particular case, the Supreme Court has seized off the issue next week. And merely because I have ceased to be a judge, I shouldn't become a citizen journalist and tell the Supreme Court what they should be doing next week.
But you're stating a principle. You're emphasizing the principle that if the investigating authorities cannot conclude a trial within a certain finite period, then bail must be the rule and jail the exception. Are we clear on that?
Absolutely. And subject to exceptions, which I said, which are well settled. These are not exceptions which I have devised right now in the course of the interview. These are exceptions which have been developed over the last 75 years in the course of our jurisprudence.
Because there is an element of selectivity also in this entire practice of bail not jail. Let me give you an example. When you were a judge, you gave, for example, a former colleague of mine, Arnab Goswami, you were heading a vacation bench at the time. You speedily granted him bail, rightly so, we believe, because the manner in which he had been confined, I believe, was he had been wrongfully confined, and therefore you gave him bail speedily. Then you have a Siddiq Kapan, another journalist, lesser known, spends more than 2 years in jail and is not granted bail. And I can give you a number of cases where individuals who perhaps do not have the same access or are not VVIPs do not get bail instantly. So the entire law of bail seems to be dependent on selectivity and who the judge is. I hear from senior lawyers, if I go before a particular judge, I know I won't get bail. And there's been this talk that that's one of the reasons why adjournments are sought, or you withdraw a particular case from a particular judge. Does that again trouble you? We are coming to the administration of justice, whether bail is also very selective.
You know, Rajdeep, let me make it very clear. So far as I'm concerned, and I've said this before, I granted bail to Mr. Arnab Goswami.
Yes.
But I also granted bail to Zubair.
Yes.
So therefore I said, well, I have granted bail from A to Z. And that was my own personal philosophy, that you must grant bail, particularly in a certain category of offences. Now, you've highlighted...
But you was missing. Yes. Umar Khalid, he didn't appear before you, but he may have gone before another judge.
I'll deal with that. Exactly the point which you are making. I don't want to duck that issue. I want to respond to that. One of the issues which a lot of people have spoken about, say, our courts today, is that we are polycentric courts or polyvocal courts, not really polycentric. That's Lon Fuller's phrase. We are polyvocal courts. Now, what is meant by a polyvocal court? With the kind of volume of litigation which we have, say 80,000 cases, 70,000 cases being filed every year in the Supreme Court. No Supreme Court in the world, perhaps except for the Brazilian Supreme Court, deals with this kind of inflow of cases. Now, as a result, what happens is this. You have 34 judges in the Supreme Court. Obviously, all 34 can't sit down together and, deal with one case, because then you wouldn't be dealing with cases. So we sit in batches of 2. We sit occasionally in batches of 3, but usually in batches of 2 judges. So you have 17 benches. Now, with 17 benches deciding cases, you're bound to have a polyvocal court where, personal predispositions of judges. In a very abstract sense, Rajdeep, it shouldn't make a difference as to which bench you go before. But you have to accept that, different judges have different predispositions, the way they think about our social life, the way they think about the law. When I was a lawyer, you would have judges who would be a little more, favorable to labor. Other judges felt that, our law had gone to the extreme in protecting the rights of labor and not protecting the rights of industry. So, you have different philosophies among judges. Should these be there? Should they not be there? The fact of the matter is you cannot avoid it.